Jurisprudence and punishment. Last time I talked about the semantic theories of law, which claim that theoretical disagreement in law is impossible or very limited because lawyers and judges must agree about the meaning of the phrase the law in order to be able to argue about what the law requires. Dworkin rejects the semantic theories because he thinks that they are incompatible with the practice of law, which evidently contains many examples of theoretical disagreements about what the law requires. To settle these disagreements, lawyers and judges must and often do engage in interpretation. Last time, I gave an overview of Dworkin's verbose and somewhat obscure remarks on interpretation. As you would remember, he compared the kind of interpretation involved in law to both literary interpretation and the interpretation of social norms over time. But if you are like me, those comparisons might have struck you as a bit too abstract. So let's try to figure out what exactly Dworkin means by interpretation in the context of law. We can classify interpretations in various ways. One way that is not terribly helpful is by subject matter, such as thinking of literary, artistic, psychological interpretation as different kinds of interpretation. But a better way of carving out types of interpretation is by objective and methodology. There are two types of interpretation in terms of its objective and methodology. First, there is conversational interpretation, which concerns only the intended meaning of statements. For instance, if you are helping your mom in the kitchen and she says, "Please bring me some sugar from the pantry," you need to figure out whether she intended confectionery sugar or granulated, refined, or brown sugar. You need to also figure out what she intended to mean by some sugar, a cup or a 5-pound bag. Second, there is constructive interpretation, which goes beyond the intended meaning and tries to attribute to statements the best possible meaning, which may or may not be the intended meaning. To see how conversational and constructive interpretations might differ, consider this example. The philosophy department needs to hire a new professor. The chair puts a committee together and he instructs them to hire the best candidate. And by the best candidate, he was referring to an applicant named Andy, whose application impressed the chair most. If the committee engages merely in conversational interpretation, they would try to figure out whom the chair intended by the words "the best candidate." Once they do that, the only thing left to do is hire Andy. But a committee using constructive interpretation might behave differently. They might say, whom the chair thinks is the best candidate is irrelevant, because Andy might not be the best candidate. So we should act on the principle laid out by the chair and focus our efforts on determining who the best candidate actually is, rather than whom the chair intended us to hire. And as a result, they might hire someone other than Andy if they come to the conclusion that Andy is not the best candidate. The way the law is to be interpreted, according to Dworkin, is constructive. Rather than just figuring out what the authors of statutes and previous court decisions intended, judges must identify the best possible principles laid out by legislation and judicial decisions and implement them in the best possible manner, even if the implementation could have been surprising to those authors. For instance, in 2013, the U.S. Supreme Court decided that same-sex marriages are protected by the 14th Amendment of the U.S. Constitution based on the idea that not recognizing same-sex marriages as legal is a violation of the equal protection of the law. The people who authored and ratified the 14th Amendment could not have possibly intended to include marriage equality under the umbrella of equal protection. But the court did not limit their interpretation of equal protection to those intentions. Instead, the court treated equal protection as an abstract principle of justice and fairness and came to the conclusion that the best formulation of that principle would prevent the government from discriminating based on sexual orientation. But there are still different approaches to constructive interpretation, which are loosely referred to as conceptions of law or theories of jurisprudence, which provide conceptual frameworks for constructive interpretation of the law. There are three major theories of jurisprudence. The first one is conventionalism, which is the view that the law is legal conventions established by past political decisions and nothing else. Interpretation of the law must be based on those conventions. Second, there is pragmatism, which is the view that the law must be enacted and interpreted in a way that is in the best interest of the community as a whole, without regard to any past political decisions. And finally, there is the working zone theory, law as integrity, which is the idea that the law must be enacted and interpreted to express a single, coherent scheme that balances justice and fairness in the best possible way. In the coming lectures, I will discuss each one of these theories of jurisprudence in fine detail. But one thing we need to notice now is the fact that each conception of law has something interesting to say about the coercive nature of the law. Conventionalism, for instance, leans very heavily on uniformity over time. The reason, for example, that the city can tow your car if necessary by force when you park it in the wrong spot is that that's how it has been in the past. Here, the questions of whether towing ordinances are good or bad for the city and individuals is largely irrelevant. Even if towing makes people miserable and traffic not any better, sticking to the convention provides a sufficient justification for enforcing it, even by coercion. Yet, still interpretive questions and theoretical disagreements might arise even from a conventionalist point of view. For instance, an individual parks his car at a prohibited location by necessity. It broke down. Should the city be allowed to tow it if he is able to bring a mechanic to the site quickly enough and move it himself? Here, legal conventions of argumentation and analogy will be brought to settle the question of what the law requires, which may or may not settle the dispute. If it doesn't, the judge might be in a position to make new case law, again based on conventions about how new case law should be made. Pragmatism would take a different approach, which sees the benefit of the community as the justification for the coercive nature of the law, rather than any prior political decisions by legislatures or courts. A pragmatist judge might, for instance, find that the city should not have towed a broken down car because doing so would encourage future drivers to continue driving unsafe vehicles instead of pulling over immediately. In pragmatism, there is even more room for theoretical disagreement than conventionalism because it is easier to disagree about what is best for the community as a whole. And finally, law as integrity justifies the coercive nature of the law by trying to ground it on a coherent set of principles of justice and fairness. If, for instance, the mayor can park in the prohibited zone when his car breaks down, so should be able to an average person. We will come back to conventionalism, pragmatism, and law as integrity in the future and discuss them in detail. But now I will focus on the coercive nature of the law and its most obvious manifestation, punishment. As far as we can tell, punishment is a universal characteristic of human social organization. Every society we know has it. But what is punishment? Punishment is best defined as a harm inflicted by a person in a position of authority upon another person who is judged to have violated a rule. Understood so, punishment has four characteristics. First, punishment inflicts unpleasantness, suffering, or loss. You cannot punish a kid by giving him a lollipop, for instance. It needs to be something the target of the punishment finds undesirable. Second, punishment is a response to an offense. If there is no offense, the harmful act is not a punishment, but senseless violence or abuse. Third, it must be carried out by personal agency. If I cheat on my wife and then get cancer, that's not punishment. Fourth, punishment must come from an authority. If I kill some innocent person and Batman decides to kill me in return, that's not punishment because Batman has no legal or moral authority to dispense punishment. Punishment could have five objectives, which are sometimes, but not always, mutually exclusive. The first one is retribution, which is the idea that the offender deserves punishment. In other words, punishment aims to give the offender what he deserves. Second, there is deterrence, the idea of using punishment to discourage future crimes by others. If I kill someone in a DUI and go to prison for 10 years for it, it might discourage others from drinking and driving. A related goal is rehabilitation, which tries to use punishment as a means to reform the offender's character and behavior. Again, if I spent 10 years in prison, I would be a bit more inclined to behave responsibly around alcohol and motor vehicles. But rehabilitation can take other forms as well. For instance, if the law sees my actions as the symptoms of a disease such as alcoholism rather than a reckless but conscious act, then I might be required to undergo addiction treatment as part or whole of my punishment. Next, there is incapacitation, which is resorted to when rehabilitation is unlikely or impossible. Imagine that I get out of my addiction treatment program and go to a bar immediately, drink a whole bottle of whiskey, and run over another person in a second DUI. In this case, the court might recognize that I couldn't help it, but still decide to lock me up for a longer time, either in prison or at a medical institution where I cannot pose a threat to others. And finally, there's restoration, which uses punishment as a tool for helping the victim and the community heal. If the court orders me to do community service to teach kids about the dangers of DUI, pay punitive damages to the family of the victim and such, the goal would be restoration. As I said earlier, these goals are not necessarily mutually exclusive. Often, lawmakers legislate and courts interpret the law in such a way that pursues most of them simultaneously. Yet, there is disagreement among philosophers and legal scholars about which goal is more important. Some even think that the justification of punishment relies on some goals only and exclude others. Now I will discuss that disagreement. There are three types of theories that aim to explain the philosophical justification of punishment. These are retributivist, utilitarian, and rehabilitationist theories. Let's start with retributivist theories, which claim that the infliction of punishment depends on what the agent deserves as someone who has done wrong rather than on any future social utility that might result from the infliction of suffering on the criminal. Retributivist theories are said to be backward looking because they focus on what the offender did in the past and base the justification of punishment on that thing alone. The most prominent retributivist philosopher is Immanuel Kant, but by no means he is the only retributivist. There are others and there are variations among their views, but they all subscribe to these three theses. First, guilt is a necessary condition for punishment. That means only the guilty can be punished. Second, guilt is a sufficient condition for punishment. In other words, all the guilty must be punished. And finally, the punishment must match the crime, which is the legal principle lex talionis. The second kind of theory is utilitarian. Utilitarian theories focus on deterrence, rehabilitation, incapacitation, and restoration. Their goal is not to give the offender what he deserves, but to effect social improvement. And that's why utilitarian theories are forward-looking. They base the justification for punishment on the future effects of punishment rather than the past actions of the offender. Jeremy Bentham and J.S. Mill are among the best-known examples of utilitarian theorists of punishment. Broadly, utilitarian theories subscribe to the following theses. First, social utility is necessary for punishment. That is to say, when punishing someone will cause more harm than good to the society, punishment should be withheld, even if the offender deserves punishment. Second, social utility is also sufficient for punishment. Even in cases where the target of punishment doesn't deserve it, punishment is justified if it will lead to the greatest net benefit overall. If that was too abstract, let's imagine this. Someone living in a very pious society vandalizes a sacred object such as a religious relic. The perpetrator is unknown, but there's a suspect. However, the court doesn't have much evidence to convict him, and let's say he's actually innocent. But the public is enraged, and they are out for blood. It is clear that if the court doesn't punish the suspect, there will be riots which might cause great loss of life and property. In such a scenario, a utilitarian minded court could punish the suspect even though the court actually thinks of him as innocent, just so that the crowds calm down. And third, utilitarians think that the right kind of and amount of punishment is the one which will do the most good or at least inflict the least harm. If, for instance, executing someone who steals a loaf of bread will lead to the best outcome overall, then that's the punishment that would be favored by a utilitarian. And then there are the rehabilitationist theories, which see crime as a symptom of mental illness which needs treatment rather than punishment. They focus on the rehabilitation of the offender. Rehabilitationists aim to abolish punishment and replace it with psychotherapy. So it is not really a theory justifying punishment, but really an attempt to get rid of it and replace it. Here are some relatively famous examples. Among these, Karpman summarizes rehabilitationist philosophy best. Criminality is but a symptom of insanity, using the term in its widest generic sense to express unacceptable social behavior based on unconscious motivation flowing from a disturbed instinctive and emotional life, whether this appears in frank psychoses or in less obvious form in neuroses and unrecognized psychoses. If criminals are products of early environmental influences in the same sense that psychotics and neurotics are, then it should be possible to reach them with psychotherapy rather than torment them in prisons. As always, I would love to hear what you think. Is either theory of punishment more plausible than the other two? Or is a reconciliation or hybrid theory possible? This brings me to the end of this lecture. Send me a message if you have any questions. Thank you for your patience, and I'll catch you next time.